issues of dispute resolution. Actually, this is mostly part of what they wanted we wanted to have it as part of dispute resolution. Was in the villages mostly, and that is where we find the majority of the consumers of justice. In the villages, there are so many ways that they can do their own disputes in terms of regulating their own affairs, including land and also personal laws. And I had mentioned earlier how even they could be able to regulate boundaries. They still do it. I know of some groups that do it. So the land dispute tribunals, we've been having them, I think, for a long, long time. We've been having them in our legislation. Yes, we used to have it. I'm not so sure right now. In a way, it involved the provincial administration then, and maybe some women representatives. We say public, they could pick some members of the public, and they will sit down and agree on how disputes on land were going to be dealt with. But yes, I think it's been done away with, because after that, I think that is the second limb of your question, my lady, is that we have ELC, which has the mandate to do all this irrespective. On the second limb of personal law, how we arrived at that, it was very pertinent that some communities wanted to do their own things differently, as long as the rider it's not repugnant to justice and morality, and it's not against the written law. And we were able to come up, like even, for example, what we have even right now in our constitution, we were able to come up with Curtis courts. I remember there was a lot of fightings, those ones of why should we have it. But generally we agreed and we said, here, there's no problem. This is personal law. If they have their own way of solving it, so let it be. Let them solve their own personal laws, that is marriage, divorce, I think also inheritance. Can we leave it to them? Yes.
Okay. Are you done? Sorry.
It's okay.
All right. Inside the judiciary, we have something called the alternative justice system. Would you know what that is?
Yes, I do, my lady.
Council, please tell us what it is and how it works here, the role it plays, please.
Thank you very much, my lady. First, I must start by congratulating you, because I didn't know that it had come into fruition. Sometimes back, I think it was being debated upon quite a lot. Alternative sorry, was it AJS?
Yes.
I think it is to do with encouraging communities and members of our holistic society to try as much as possible to solve disputes using their own traditional way or customary methods, as long as it does not go against the norms of what I've been saying. That is not repugnant, it's not against the written law. And I believe if that is what has come up, then the backlog of case backlog will really go down.
Have you seen our policy on AJS?
No, I've not seen it, my lady.
All right, we launched it just the other day.
Thank you.
Do you know the difference between AJS and ADR?
Yes. I may talk very well about ADR because it's more or less structured. We have arbitration, we have mediation, we have negotiation. But then when it comes to AJS, since I've not seen your policy, my lady, I may not really want to say so much about it.
All right. And I understand, and you're quite right there. But let's go to something else. As Chief Justice, Counsel, you would be our team leader, and the link between us and other organs of state, including county governments. Now, you told us earlier that you are a county attorney?
Yes.
Good. Now, what did you acquire there that would enhance your link between us and the county governments? Let's just remain with the county governments.
Okay. The link, my lady, is very well pronounced, not only in the Constitution, but also in the legislation. It's very important. I mean, the judiciary cannot live as an island on its own. It must be able to interact with the other links, whether it's the links of the government or the way also you've told me, your lady, that also with the links in the county government. The link is very important because let's say judiciary on its own cannot stand on its own without being with the others. And if that one happens, then it is bound to fail. It's very, very important. Only that the overriding factor, my lady, is independence of the judiciary must be safeguarded altogether. But does not mean that when you link with the other arms of government or also the county government, then that independence is eroded.
Would Council know, we are still on the same thing, so yes, whatever you wanted to say now, you can continue saying. But we are looking for your knowledge of what we have done with county governments.
Yes.
Administratively to support them, and what they have done themselves to enhance the performance of the judiciary in access to justice, because that's our core mandate.
Most obliged. Thank you, my lady. What came into my mind, definitely, that is the first thing is I remember there was a circular that county governments should be able to provide at least land for purposes of enabling the judiciary to put up structures, court structures. And that was a good gesture, and I know most of the counties, including also Elgeyo Marakwet, as I'm speaking right now, has already ceded out land to the judiciary so that it can be able to build structures. And the other thing that also came to my mind sometimes back is once the county government has ceded out land to the judiciary, it will also be upon the county attorney of that county and also the judiciary legal team to ensure that that property is registered under Judicial Service Commission, so that we don't have a situation where maybe with the time, if there are any altercations, it will be, the judiciary, the judicial officers in the locals might be kicked out. So that is also another very important part. Apart from ceding out land, also ensuring documentations are properly done. That will be a very important link. And the other one, my lady, is communication is key. Even this perception we have in the judiciary as maybe we don't work, or that is as judiciary, that judiciary does not work optimally. the backlog, the bad name that comes here. We could use that channel because the county governments have a very good channel of communication. Communication, not only in the sense of holding barazas, but also, disseminating issues from the county to the ward level, to the sub-ward level, all the way to the village. So you'll find even the common mwananchi in the village there would know what judiciary is doing if the judiciary can be able to take advantage of that communication system that decelerates to the people on the ground.
Thank you, Counsel. If you come in here as Chief Justice, you would automatically be the President of the Supreme Court. One of your leading roles there is to lead as the jurisprudential head of the entire institution. And therefore, in respect of jurisprudence, we would not get a better person than the Chief Justice. You will find 6 co-equal judges as far as jurisprudence is concerned, and you will be the team leader. Please explain to us what you see, listen to my question, as the role of a dissent judgment in a collegial court such as the Supreme Court.
Yes, thank you very much, my lady. Yes, as I'd said earlier, as President of the Supreme Court, being the Chief Justice, a Chief Justice is first among equal. When it comes to decision making, the Chief Justice is not at a higher rank than the others. So what does it call for? It calls for honest, fair decision making amongst all the sitting members of the Supreme Court at that particular time. And once they have, before even they can concretize their own decision making, maybe they would call for a conference and discuss issues.
Sorry, let us remain with the issue. The issue is your view on dissent judgments from a collegial court.
Yes, ma'am.
There's something we are looking for.
Yes. So, my lady, once they've agreed and there is a dissent from one of the judges, then of course the same is recorded. And it is very important because this is part of building jurisprudence. Dissent does not mean that you're not happy with what your colleagues have done. You also, this other judge is coming up with how they feel and think this matter should have been adjudicated upon. So for me, it is very clear that even this dissent maybe in future could be the reigning or could become reference point towards achieving better jurisprudence because society is dynamic. The dissent of today may not be the dissent of tomorrow. It could actually be the precedent of tomorrow.
Thank you.
Yes.
We've had critique of the Supreme Court as being the court that has created for itself unlimited appellate jurisdiction. Unlimited appellate jurisdiction. What would counsel say about that critique? Is it in fact a critique or a criticism? And what is the truth or otherwise of the original statement?
Yes, my lady, I think also this one is a matter of discussion and conjecture. Because when I look at that, what comes to my mind immediately, some case that the ones who criticize what the Supreme Court did are saying that there should be an end to litigation at some point. I think this is a new case, though I've glossed over it. I was not part of it. And from what I followed from that case is Section 35 of the Arbitration Act. I mean, towards bringing an end to litigation must end at the High Court. But after the High Court, the matter ended at the Supreme Court. So,
is counsel saying that the Supreme Court had no jurisdiction to hear Newton?
No, my lady, I'm coming from the point that you asked me about the criticism and all that. That is what came out. But I'm not saying that Newton case was a bad decided case. No, I'm just mentioning.
And that's not the issue.
Yes.
I think we must stand guided. You have said something about Section 35. The question is, arising from what counsel has just mentioned now, is whether the Supreme Court in fact had jurisdiction to hear the issues raised in Newton.
My answer would be definitely yes.
Because we're talking about unlimited appellate jurisdiction. That's what we are addressing right now.
Yes, it had the right, because, can I explain further?
Yes, of course,
yes.
Of course.
Because on issues of interpretation of the Constitution and issues of general public, then it has jurisdiction to hear those matters.
Yeah,
so for me, yes.
No, you're quite right there, but the issue is we have this category of justice consumers. The one part says this court has created for itself unlimited appellate jurisdiction. Now, we are asking you not so much your view as to whether that statement is indeed correct, but where it comes from. Any person who says that, what would be bothering them?
I actually don't think that the Supreme Court does not have that unlimited appellate jurisdiction. It does. And to answer it shortly, my mind comes to what would it be that may want other or may call for criticism, is the sense that when we look at, sorry to go back to arbitration, my lady, when you look at that arbitration issue, it's like this is a commercial dispute. If it's a commercial dispute, maybe parties would want to clear with it, finish with it, and move on and do other things. But when now the critics or criticism that I hear from that is by taking it all the way to the Supreme Court could be time-consuming and waste of money. And that is where I come from, not that I'm saying or I would agree with those criticisms.
Thank you, counsel. Let's put the question differently. What is the jurisdiction of the Supreme Court?
Yes, the main ones are to hear or to hear petitions, presidential petitions, which is the original jurisdiction. Secondly, to hear appeals on interpretation of the Constitution, and issues touching on matters of public importance. The other one also is to hear, apart from petitions, I think that one, yes, when I say apart from the petitions, that is matters of public importance, interpretation of the Constitution, and also to hear appeals from the High Court.
Thank you, Council.
Yes.
Back to you, Chair.
Thank you very much, Commissioner Acting CJ. Thank you very much, Council. And now we go to Honorable Commissioner Judge Wasame to continue with the questions. Judge, please.
Thank you, Professor. Council, from your CV, you said you have worked with the county, you have been a county attorney for Elgeyo Marakwet.
Yes, my lord.
And you have dealt with a lot of legislations, as you said.
Yes, my lord.
The biggest threat to devolution is the county assemblies.
Yes, my lord.
And the way they undertake impeachment of governors.
Yes.
Tell us two ways in terms of legislation proposals you will give governors or the Council of Governors to insulate them from this persistent and consistent impeachment motions filed.
Yes, it's true, my lord. County assemblies have been the guillotine houses for most of the governors. One of them is on the issue of accountability by the county governments also. I think a legislation should come up wherein the county governments are made to be accountable for the money they're using the county assemblies are made to be accountable to the money they're using in the county assemblies. That's very important because that will make them also know that in as much as they're watchdogs as against the county government, they should also be watched. I don't know whether I'm getting each other.
Yes, you're there. Again, another problem I find in this impeachment, it talks about whenever a vacancy arises in the office of the governor through impeachment or the office of the president. For the office of the president, the deputy takes over for the remainder of the term. And for the office of the governor, the deputy governor. What is your view on that constitutional provision? The fact that, you know, we have elected our president directly ourselves, we have not elected the deputy governors, and we are giving them fruits on a silver platter. Is it time to change that legislation?
My lord, that's a very emotive issue, and I think it's in the public outside there. The discussion is very live, and I'll be a bit uncomfortable giving my opinion on that.
Yes.
It's a very live discussion.
Yes.
Yes.
Again, under Article 193, a governor is not eligible for re-election. In terms of 193, for example, and I take this very important, 193(2), I think this is the one which deals with impeachment, has been found in accordance with any law to have misused or abused a state office or a public office or to have contravened Chapter 6 is not eligible, among other things. But the most critical aspect which I want you to address is this. which is 193.3, which says a person is not disqualified under clause 2 unless all possibility of appeal or review of the relevant sentence of the decision has been exhausted. Now, this is my question. For you to exhaust the appeal process, the review process, and to overturn the decision of the Senate, both as a sitting president and as a governor, there shouldn't be a situation whereby you are removed today, maybe at 11 p.m., and the following morning you find somebody in your office before you have exhausted the review process, the appeal process, and the sentence has not been set aside or confirmed, the decision. Now, is it time, because the Constitution is not clear, time for us to give governors maybe 14 days, maybe 30 days, to exhaust that appeal process or review process, to either for the sentence to be, or the decision to be overturned or confirmed in terms of timelines of the impeachment process?
Yes, my Lord, I would want to answer it this way. Yeah, it's a very tedious process, and especially after the Senate, then to the court, and all that partakes to the point of having exhausted all the channels. My Lord, I think also that is the reason why these courts are really clogged with so many cases, because things don't seem to move as per what is provided for by the Constitution. I really did not get the second limb on how you crafted the question, my Lord.
I said, is it time for us to propose a legislation to give governors time within which to challenge the decision before somebody takes over their office after impeachment?
I think that will be natural justice, my Lord. That is given time, because you're saying that immediately after impeachment, let's talk about the deputy
governor.
Governor takes over.
Yes.
And then the governor had not exhausted the appeals, or had not even started the channel of appealing against the decision of the Senate.
Yes.
That it is a high time we give them time to exhaust those channels, and with a time limit.
Which means, if he cannot be disqualified from running for a second term, cannot be disqualified from running for a second time because he has exhausted the mechanisms provided under the Constitution, does it go without saying that he also does not lose his office within the first or second day of impeachment? Is there timelines which we must provide? The fact that there is no timelines after impeachment.
I think so, my Lord. I think that is an issue where one has to really think deeply about it.
Okay.
Yes.
Again, on impeachment, and if it's difficult, you don't need to answer. Under Article 145C, 1C, one of the grounds for removal of the President of the Republic is for gross misconduct. Under Article 181, 1C, which is also similar in terms, among other issues, is abuse of office or gross misconduct. For the president, the word abuse of office is not used under the Constitution. But for the governor, both the word is abuse of office or gross misconduct is used. Do you have any reasons for that? Or any proposals? Or your views?
I think abuse of office will call for a higher standard of proof. Gross misconduct maybe could be taken at almost face value as long as it can be proved that it was gross misconduct. That's my thinking about it.
Okay. There is a debate about whether a speaker or a governor is an employee. Therefore, the labor court has jurisdiction or has no jurisdiction. Are you aware of that debate?
No, I'm not aware of that.
You are not aware of that debate?
Yes.
Okay, so I will not ask you that. And this is my last question. If I tell you that the biggest threat to national security in our country is tribalism and or nepotism, 2, populating wrong people in a sensitive places, and thirdly, the way we conduct our elections in that priority, among others, and then other things follow. Will you agree?
Yes, I do.
Thank you very much. I wish you well.
Thank you, my lord.
Council, you don't want to elaborate a little bit
Yes.
with what Judge Wasame asked, or you're okay?
I'm okay, thank you.
Okay.
Yes.
Thank you very much, Council. It's now the time for Honorable Commissioner Judge Majaja to continue with the questions. Judge Majaja.
Thank you, Chair. Good morning once again, Council.
Good morning, my lord.
Part of my task is just to look at your sample writings. You presented 6 samples. One was a written submission in a land case at the Kajiado ELC. Second one was election petition Kajiado West, a submission for one of the respondents. The third submission was a running down case at the Kajiado Magistrates Court. Then you presented 2 submissions on a no case to answer in respect of the Magistrates Court, and another submission in opposition to an injunction application in a succession court in Nairobi. I must say that the submissions are clear, well written, and I will ask you questions related to not necessarily on the subject of the case, but technical issues surrounding what you have written and from your own experience as set out in your CV in relation to the work you do. First, I just want to follow up from what my colleague, the Chief Justice, Deputy Chief Justice, asked you about the Supreme Court. That's an important court. Have you had a chance to read the strategic plan?
No, I've not had a chance to read the strategic plan.
You have not had a
yes.
chance to read
Yes.
the strategic plan. Have you read the judiciary strategic plan?
I've glossed over it.
You glossed over it.
Yes.
Okay, but you worked in management positions before?
Yes, I've done so.
Okay, so just tell us very briefly what you understand by the term knowledge management, and how it relates to the work of the Supreme Court.
Yes. Thank you very much, my lord. Yes, knowledge management to me literally means you must, like if it has to do with Supreme Court, you must have sound legal understanding of issues in terms of knowledge, in terms of reading, maybe in terms of paperwork and all that, so that you can be able to apply the same in upcoming cases that may be brought before you.
Okay, well, thank you. You were involved in the constitutional making process.
Yes.
As one of the commissioners. So probably you can tell us what is the doctrine of judicial deference, the doctrine of judicial deference, and in telling us what it is, probably would give us an example from decided cases in the High Court, Court of Appeal, or Supreme Court, and what is its constitutional basis. The doctrine of judicial deference as it applies to the Constitution, and any examples of that deference from decided cases within this jurisdiction.
Maybe, Your Honor, sorry, my Lord, you can give a guidance a bit on what...
Okay,
yes.
What do you understand? What do you mean by defer? If a court says it is deferring to another institution, what is that? Well, let me put it this way.
Yes.
A court can say that because this subject matter is being dealt with by another institution, we will not deal with the issue. Basically, I'm giving you the answer. That is called judicial deference.
Yes.
So the court may say, we are not dealing with this matter because there's another institution.
Thank you.
So having given you that answer, can you tell me what is the constitutional basis of that kind of doctrine, and whether you know of any cases that it has been applied either in the Supreme Court, Court of Appeal, or High Court?
Yes. What comes to my mind, if I get that very well, is when, I don't know whether it was in the Supreme Court, but I remember a ruling that was given by the court. The court said, we may not want to deal with this matter as it is before us right now, because the same can be dealt with elsewhere. It was a political issue. I think it dealt with nomination of members to a political party, and the court put its hands up and said, no, you go to the political parties tribunal. I remember there was a matter of that.
So on what basis, what constitutional basis is that kind of doctrine founded on? And why do you think it is important sometimes for the court to defer?
Could it be separation of powers?
Okay. Let me go to the next question. Again, this is from your position at the Constitutional Review Commission. The Supreme Court occupies a very important role in the hierarchy of the courts in constitutional cases. There is a phrase in section 259(3) of the Constitution that says, in interpreting this Constitution, every provision of the Constitution shall be construed according to the interpretation that the law is always speaking. That the law is always speaking. What do you understand by that term in terms of constitutional interpretation?
Yes. When interpreting the Constitution, you look at it from a very holistic approach. And the holistic approach is the doctrines that the makers of the Constitution and the people wanted the Constitution to be made, that is Wanjiku, wanted the Constitution to safeguard, so that it brings issues of values, integrity, impartiality, equality, and all that, so that as you're interpreting the Constitution, you look at it from all those global areas to give it a living, to be a living, not only in paper, to be alive to the needs of the people.
Can you give us one case that demonstrates that principle you're saying, one decided case of the Supreme Court?
And that one, I can also give the case of Murwatetu. Because then, when the Supreme Court ruled that the judges or the magistrate's hands should not be fettered in terms of their own discretion, then it was giving effect to the fact that once a matter has appeared before a judge or a magistrate, then they can use their discretion in terms of sentencing. And I think it captured the values of that interpretation and also the dynamism of the society. We are dynamic and we're moving on.
Yes. Now that you have mentioned the Murwatetu case, which I'm sure if you have been watching the interviews has been really the subject of discussion, can you tell us what specific constitutional provisions or doctrines that the court are used to arrive at that conclusion you are talking about?
Please, may I
Yes.
get the question again, my lord?
You have said what the Murwatetu decided, that it gave magistrates discretion. Of course, that was on the basis of certain provisions of the Constitution.
Yes.
So can you tell us what provisions of the Constitution are these the court interpreted to enable it reach that conclusion which you have talked about?
Oh, yes. I think basing on the fact that the Constitution per se does not provide for a death sentence, and here we have the Penal Code, was it Section 204, providing for the death sentence. And also the other issue is once a judicial officer, a magistrate or a judge would have gone, if we look at the issue of discretion, what happens when it reaches the point of sentencing? What is it that mitigation in sentencing, what will it help once the sentence is mandatory death sentence? So then it takes away the powers of the magistrate or the judge from really looking at what these magistrates could have been able to do with the mitigation. Another point also touching on that is different circumstances may be looked at, because yes, we can have the penalty saying death sentence is, murder, mandatory death sentence is, for murder, mandatory sentence is death.
So,
But
Counsel, maybe
yes.
just to redirect you, my question was specific. The court, the reason why the matter reached the Supreme Court is because it raised constitutional issues. So I was asking, what is this? Tell us just one provision of the Constitution that the court was expounding in order to reach the conclusions which you are talking about.
Yes.
Just one provision.
Okay. Provides that justice should be arrived at from looking at issues and arriving at it fairly and equitably, depending on the facts of the case.
Okay. Is there a specific article of the Constitution that deals with that particular aspect?
I may not mention the specific article, but I know in my mind.
Which substance? What is the substance of that article? If we don't know, say the number, maybe the substance of that article that says the court should do what it's saying it's doing. Article on fair trial?
Yes,
perhaps?
article on fair trial.
Okay.
Yes.
Let me move on to another substance of another experience which you have had. Yes. You were a member on alignment of higher education to the Constitution.
Yes.
Which means, and I guess you familiarized yourself with the education system. You looked before you, I mean, if you are looking at higher education, you looked at the education system, so you understand some of the issues that we deal with, and you are a parent also, isn't it? So the question I want to ask, to Article 27 of the Constitution, which is a pivotal provision, talks about equality and freedom from discrimination. That is an article I'm sure you're very familiar with. Yes. So I want to ask you, we have just completed KCSE, and government has a policy of restricting the number of pupils from private primary schools who can join national public secondary schools. Am I right?
Yes.
Yes. So how is that provision justified in light of Article 27? Can you just elucidate to us?
Yes. I think what the government actually is doing is to ensure there is fair access to education for all. And fair access to education for all is looking at, and if I take you back, my lord, to what we did in the task force, is like we were looking at these regions that they may have had not even TVETs. And the propelling factor was, let us ensure that we have colleges, that is universities, TVETs, to be put up in these regions so that we bring, the issue of, we do away with the issue of feeling that others are marginalized. So that is where we're coming from, that to expose diversity, let us move also the universities to other regions other than having them concentrated in areas that were well known to be concentrated. And when you raise this issue of education, my mind is very clear. It's still the same issue of diversity. Can we have almost an equal sense of education to each and every child?
So what is the term used in Article 27 for that kind of intervention?
Can I maybe look at the Constitution, my lord?
Well, the answer is there. Maybe look at it. It is called affirmative action. So I'll move on to the next question. You have, in one of the cases you provided for us, in one of the cases was an election petition, Kajiado West. And from the jurisprudence of this, in fact, I would say, if you look at all the reported cases of the Supreme Court, a third of them are to do with election petitions, isn't it? A third from the time inception. The question I want to ask is, one, does the Supreme Court have jurisdiction to deal with a third appeal emanating from a petition of the magistrate court in respect of a member of a county assembly? And if so, why?
Yes, a third appeal emanating from a member of the county assembly. My lord, I think the factor here that runs through is also the issue of time. The time given for the hearing of this petition from maybe the lower court up to the time it reaches the appeal court.
So in the, let's take it step by step. So in the magistrate's court, it will take how many months?
I think there's a blanket number of months that was given, 6 months for all.
Okay.
Yes.
6 months. And then in the High Court?
Depending. Maybe even they can take the 6 months in the magistrate's
Okay.
court.
Then you appeal to the Court of Appeal. How long?
If the time has run out, I think there would be a problem doing all those appeals.
So your understanding is that because of the time frame, the Court of Appeal and Supreme Court may not have jurisdiction.
Because of the time,
Because
they
of
may
the
not,
time.
as of what I see.
Okay. So if you prosecute your case fast enough,
Yes.
you will be able to get to the Supreme Court.
No.
So what is the distinction? You tell us.
If it has to go to the Supreme Court, then it's just on those two issues of actually it should be on that issue of interpretation only.
Yes.
But otherwise, it doesn't have to go to the Supreme Court.
So what is the jurisdiction in a third appeal to the Supreme Court? So does the Supreme Court have jurisdiction to deal with a third appeal?
Depends on the circumstances. What are
So
the issues that
tell
have
me
been
the
raised?
circumstances.
If it has to go to the Supreme Court, we just follow the jurisdiction of the Supreme Court. What is it that the Supreme Court can be able to do?
Okay.
Yes.
And in terms of the Constitution, the Elections Act, what is the jurisdiction of the Supreme Court?
Yes. Jurisdiction of the Supreme Court is to hear presidential petitions, or am I?
No. In terms of that is original. We are dealing about appellate jurisdiction.
Oh, yes,
In election, specifically in election petitions emanating from the magistrate's court.
If it has to be on appellate jurisdiction emanating from all the way from the magistrate's court, will it be to do with an interpretation of a constitutional issue in that petition?
Okay, that is your view.
That is my view.
Okay. On the same issue, again, this is a case you did. One of the cases, the submissions you gave to us.
Yes.
One of the issues was there was a case where you sought an injunction in respect of a plot somewhere in Bissell, isn't it?
Yes.
Simple case of an injunction. But I noted from your submissions, you cited extensively Article 60 and 62(2) of the Constitution because it appeared that there was a dispute as to ownership. The court dismissed that application, isn't it? The High Court, at least I looked at the reported case. So tell us, under what circumstances this particular case would proceed up to the Supreme Court, or rather, under what circumstances would the Supreme Court have jurisdiction to deal with this particular case?
Yes, my Lord, I just came to know after I'd filed it that the matter actually was taken to the Court of Appeal. Yes, I may not be able to.
No, I'm just saying,
Yes.
hypothetically, party comes, you have an injunction, it is dismissed, you talked about Article 60. Under what circumstances would such a case reach the Supreme Court? An application for injunction, a ruling from the High Court.
Yes. From the High Court to go to the Court of Appeal, my Lord, then the Court of Appeal has very limited jurisdiction in terms of allowing some of these prayers, like this one of injunction, under their rule. I think it's Rule 5.2. And if it has to go to the Supreme Court, then, first of all, it must be certified as appealable by the Court of Appeal. Yes.
And what are the considerations when the Supreme Court or the Court of Appeal or Supreme Court is certifying a matter?
What are
the considerations, the factors the Supreme Court or Court of Appeal takes into account when certifying a matter?
Is the weight of is the weight of the application, is it that if it is not given, it will outweigh or it will create more problems other than if it had been given? Like if a house was going to be demolished, that is an example I'm giving. And if we see that, or the court says that no amount of damages can be able to restitute that kind of a person, then to be able to give out that.
That is the test for certification.
Yes.
Okay. Let's move to another aspect. I'm just limiting myself to the work you have been doing. You talked about FGM, and I think you have done a lot of work for the girl child. FGM is a practice that I think that must be eradicated. And under the, do you know, are you aware of the Maputo Protocol? Maputo Protocol?
No, I'm not aware of that.
The Maputo Protocol. The protocol, you are not aware of it?
No.
Okay, so I'll leave that question. The final question I want to ask you, one of the cases you submitted is a succession case.
Yes.
And what came out to me was that this was a succession case of the deceased. The deceased, I believe some lady,
yes,
who died sometime. The succession cause was filed in 2008.
Yes.
Correct?
Yes.
Went on, and the submissions were in respect of a summons for injunction filed in 2020.
Yes.
In fact, the submissions are in November. So from the time the succession cause was filed, that is how many years?
2008. That is 2008 to 2020?
To 2020. Yes, that is 12 years.
12 years, yes.
12 years. You would agree with me that that is an inordinately long time.
It is.
It is. Now, you are Chief Justice Yano. Can you tell us some of the interventions you would make to ensure that this kind of case is dealt with expeditiously? This is a succession case. Tell us some of the strategic interventions you would make.
Yes, I may want to look at two. One is to evaluate first what could have really caused the delay in that. But when you look at it, is it lack of enough judges to work on these matters? If that is the case, then we work towards increasing the number of judges. If it is, I look at it also from the issues of bringing in ICT, vibrant ICT. ICT is already there and working on it. Also, I would want to look at mediation, and especially what we have right now, the court annexed mediation. I see it working in Eldoret very well. And partially I've seen it in Milimani, but in Eldoret it's working very well, and especially on these family issues, because usually most of these matters are taken to the annexed the court annexed mediator, and we are given time. We'd even run from day to day, and we take Usually it takes only about a week or so, and we are through and we get our judgment.
So I hear 3 interventions. You've talked about mediation. This is a family case.
Yes.
You would promote mediation seriously,
yes,
and would finish these cases.
Yes.
ICT. This is a succession case. It is in, say, it's in Kajiado. How would ICT deal with this kind of issue? Maybe just give us 1 or 2 points.
Thank you very much, my Lord. Yes, it's been a problem really, and especially when filing cases physically. You find that you waste a lot of time. You come to court, you're in the court registry, day in, day out, and you find that you can even take about 2-3 days before even filing a matter. And when you look at it, actually, it's not that they're refusing to take your documentations for filing, but it's the caseload. And I've seen what is happening right now. When we file using ICT, unless there is a problem, your filing goes through very fast.
So let me just pause you there. So this one of 20, it will be filed in a day. But how does ICT make sure it doesn't remain in the system for 12 years?
Yes, my Lord, tracking. Tracking is very important. So that it will be easy, just at the touch of the button, the judge or the magistrate will know, really, this matter has taken so long, can it be afforded dates?
Okay.
But you see, like when you pile, when we look at our registries, how files are piled up to the roof there, be a bit of a problem for even the judge or the magistrate himself to track. They'll have to depend on the clerks throughout.
And finally, and I'm sure because you have been watching these interviews, you have thought about the last intervention you said would be to increase the number of judges. You are aware we have 40 judges waiting out there to be appointed by His Excellency the President. Tell us how you intend, if you are appointed as Chief Justice, to resolve that particular issue.
Thank you very much, my Lord. Yes, the lack of those 40 judges could be said to have immensely contributed to the judiciary being blamed as not really being productive. The question you've asked me is, what would I do to ensure that these judges are processed to come to the mainstream in engaging and doing the judicial, the judicial work in the judiciary, so that to ensure the core mandate of the judiciary is met. As you can see, my Lord, from my CV, one of my core leadership principles is teamwork. I really believe in it. And when I look at the constitution of the Judicial Service Commission, I can see it is so well representative. I think almost all the stakeholders in this country are represented, well represented. I'll take an easier step. My easy step will be this. Directly opposite me sits the Attorney General of this good country of ours. I'll start caucusing with the Attorney General. First and foremost, I start from here. He's the chief legal advisor to the government. We sit down with the members of this commission. First of all, let us evaluate as members. What is the problem? When did the rain beat us? Let us first of all caucus from here, discuss, exhaust, and come up with a way forward. And for me, if we can be able to do that, come up with a way forward, then if the next way forward is to go and see or meet with the appointing authority, then it would have come. It is an initiative of Judicial Service Commission. So would be there with the Attorney General, and it will be upon maybe the Judicial Service Commission to say, maybe the Chief Justice, Bwana AG, another two, move together, go and see the appointing body and ask him, kindly let us have this country move. Swear for us these 40 judges. That way, we can be able to use that link properly, because that link is there. It's only that the link, of course, may not be misused, may not be seen to be misused by eroding the independence of the judiciary. And when Kenyans see 2 or 3 people moving together, then even that connotation of the judiciary is being compromised may not arise. And sometimes I feel like joking. If we have a lady CJ, like for me, I think I just pick a phone call and call Mama Margaret, kindly call me for a cup of tea and get me to know the moods of Mzee. Can he get to hear us? And then I come and talk to my members of the commission, we move and go and meet Mzee for purposes of having this. That's a joke, by the way, my lord. That is how I'm saying it. Yes.
Thank you, Council. Chair, that is the end of my questioning. Thank you.
Honorable Commissioners, Council Yano, I'm suggesting we take a break now for about 12 minutes, and we'll be back at 11:15. And the Council, our Secretary, Anna Madi, will show you where you can rest. Thank you very much, Commissioners. 12 minutes.
Yes. I can leave them here, isn't it?
Do hereby swear by Almighty God.
The Director General, National Youth Service, Matilda Sakwa, is happy to announce recruits passing out parade on Saturday, 24th April 2021, starting from 9 a.m. at the National Youth Service College, Gilgil. Due to COVID-19 restrictions, the public is not invited to the venue, but encouraged to watch live on KBC Channel 1 and KBC Live on YouTube. National Youth Service, huduma kwa taifa.
Nichukulie tensema ndani ya matatu Yaani mtu mzima na miaka zake hizo miaka zote. Mtu ajui kuandika noti tu peke yake. Kusema kweli itasaidia gani?
Nini nakusaidia na nini?
Nauliza. Yu bwana.
Chukia.
Amanzo.
My name is Sophie Wanjiko Onyango. I'm known as Shiko Onyango. My brand is Tribal Trends by Shiko Onyango. I'm a jewelry designer. So I started my business back in 2013 and I'm passionate about it. This is what I do for a living and this is my life. This is where the art and fashion. Sikusomea hii kazi. Hii kazi nilianza kujua mambo ya beads nikiwa form 2, that is back in 2016. So nikaanza tu kujifundisha pole pole. Nilianza tu ya kushona hizi beads ndogo ndogo kama rings. Kwenye nilikuwa nasomea kwa Masai. So from there nikaanza kuipenda tu. So decide since napenda sana mambo ya fashion, ni nini naweza fanya kumix beads, fashion na art. So hapo ndio Tribal Trends ilizaliwa. Nikaanza create designs mimi mwenyewe, naangalia tu vitu hivi, nafikiria si ninaweza tengeneza beads zinakaa hivi na hivi. Mostly naangalia na kama hii ndio inatengenezwa hivi, ndio isitengenezwe na beads. So hivyo ndio create vitu, hivyo ndio nipata ideas. Yeah. Nilianza kuuza earrings, zile nilikuwa nauza 100 there. And then from there, I started buying beads pole pole. Kuna shop nilikuwa napelekea tare, nilikuwa nipelekea necklace. But walikuwa nilipa maybe 500 per week. Na maybe wakana beads zangu like za 5,000, but they pay me slowly. From there I said hapana, mimi sitaka nifanyia mtu pesa alafu ananiexploit. So nikaanza tu kujishonea peke yangu. Then my boyfriend then, he is my husband now, akaniambia nifungue Facebook page. From there I started posting my stuff. Nikitembea tu nikaanza kusema and these beads they can do a lot of stuff. Nikaanza tu kuangalia fashion magazines, naangalia what can beads do. Yani nikaanza tu kufunguka tu akili pole pole. So nikaanza tu pole pole. Design yangu ya kwanza nilitengeneza, kuna mtu alipenda. Na niliuza 3K. Because a lot of money. Sijauza necklace hiyo time hiyo pesa. Necklace nilikuwa nauza pesa mingi sana, ilikuwa 500. Nikakuwa excited, nikasema hizi vitu ni vitu mimi nimelalia masikio. So I can do vitu kubwa kubwa. So nikaanza kufanya necklace kubwa kubwa. Zingine zina backfire, zitokee vile nafikiria. But siku give up. Nikaendelea tu kupush. So nikasema nilianza na capital ya 500. I went to Kariako, bought some beads. From there, sasa ndio nikajua kumbe beads inaweza fanya vitu. So after 3,000 by then nitabada nafanya shampoo gani. Nitasema hata hiyo msili. Nataka hivi alafu kumbe niweza shona. I start from I have a lot of styles here. I have a beaded bra. I have a beaded gown. I also have a panty. I have so many assorted beads, bead wax and designs. I have like this one which is made out of beads. It's easy to wear. You can wear it with anything, but kuna designs zingine huwezi vaa tu kila mahali ama mahali popote. Lazima ikuwe na specific clothes ndio uvae. But kaa hii unaweza vaa hata ukienda job, unaweza vaa anywhere by the way. So kila style hapa iko na type ya nguo ya kuvaa. Na kuna vile pia inavalia. Huwezi tuchukua tu bidhaa yote uvishe tu kwa nguo juu hivyo. No, hayaki hivyo. Kila kitu iko na style yake ya kuvaa. Huwezi chukua choka uvae na pull neck. Haita make any difference. Yani haitakaa niko umevaa anything. But unaweza chukua choka uvae na nguo iko open huku juu or off shoulder. Itakaa vizuri. There's some which are locally available, like this one belts. They are made in Kibera. Hizi ni mifupa za nyama, zile nyama yake anakula anatupa. Kuna mtu anachukua, anaosha, anasugua, anazungusha, anaishape, inakuwa hivi. So this is locally made. Beads, the ones that I'm using, they come from China. Nikifanyia mtu anaona kazi yangu ni nzuri, unapata mtu amepost kwa Facebook page yangu, ama ameshare na mtu, alaye mtu ananicontact. Client yangu ni mtu yeyote mwenye anapenda style, na mtu yeyote mwenye ako bold kuvaa hizi pieces, mtu mwenye anajiamini pia, na anataka kustand out. Hiyo ndio client na target. Pieces zangu zimetumika kwa kustyle musicians. Yemi Alade ametumia piece zangu kwa hii music yake mpya. Angelina Kije alivaa hii piece yenye nimevaa saa hii. And Masika artist wengi Kenya wamevaa na pia international wamevaa. Yeah, so niko proud kwa kazi yangu. Nikiona kwa TV kazi yangu I feel so proud because si ati nikianza sikuwa najua nitafika hapa, but hiyo kung'ang'ana, hiyo kusukuma ndio imefanya nifike hapa kwenye niko sasa. In my line of work, it's tiring, but we do it because we love it. It takes a lot of time, na watu hawaelewi. And when you charge for time, one thing, because it's something like, take a whole or 2 weeks, you have to charge more to pay yourself for time and more. But if you charge, you say, yeah, there, and but I understand. But when you're not buying it, you understand, you're America effort, and see rahisi. Na sasa mtu anajaribu kukompea kazi yake na kazi ya mashini. Haiwezi kuwa the same price. Najua naenda mbali, because bado sijafika kwenye nataka. Nimesonga. Hata kama ni one step, nimesonga. Yani nimesonga sana. Because zile vitu nitanafanya kitambo saa hii, hata siwezi compare. Mimi in the next 5 years, nataka nikuwe na shop kubwa zaidi ya hii. Nataka ni employ watu wengi zaidi. Sasa hivi niko na watu 4 wenye wananifanyia kazi. But nataka nikuwe na watu wengi na nataka kila mtu ajue about Shiko Onyango in future. And then nataka pia gava isaidie watu wenye wako chini wenye wanajaribu kujikuza talent wise, because most people are talented but hawana uwezo. Unapata mtu kuna opportunities zenye hawezi pata kwa sababu hawezi afford. Example, I'm invited to the African London Fashion Week, which I cannot afford. Sasa opportunity kama hizo watu hawezi showcase kazi zao kwa sababu hawawezi. Unapata pia exhibitions mingi hapa Kenya, mtu anatamani kuenda kuonesha kazi yake but it's too expensive for them, they can't go. Sasa mtu ana give up, anasema hii kazi yangu sasa. Hivyo ndio mtu lose hope, because hata mimi nilikuwa hapo kwenye nilianza, ni mtu alinipatia chance. Si ati nilikuwa na pesa, mtu alinipea chance akaniambia kama showcase kazi yako hapa, you never know. Nikaenda nikafanya my first run hapo, hata yakanijua watu kabai vitu. If we can get a way of sponsoring people, helping people get their work there, si kila mtu anaweza kuwa employed by the way. Tuoneshe watu they can eat from their talent. I want to encourage someone out there. It does not matter where you come from. As long as you believe in yourself, you can achieve everything that you want. I was born, I never went to a good school. I never went to college, but I believed in myself and my talent. If you have a talent, sikae chini ati useme, this talent I need to get a job. No, that's your job. You have to make it work. Hakuna kitu inakujanga in a silver platter. You have to work for it. You have to. And you have to make decisions, hard decisions. You have to decide, do you want people to see what you're worth? If you don't believe in yourself, no one will believe in you. And that's what has kept me going. Sometimes I wake up feeling bad, but when I look at my work and I say, hi, I'm the one who did this, I can do more. I know I can do more. So every time I have that zeal to do more every day. And that's the only thing that keeps me going. Richness is better than any. Just make it work. You can find me on Instagram. My tags are Shiko Onyanga, SHIKOONGA, Shiko Onyanga. On Facebook is Tribal Trends by Shiko Onyanga. My workshop is in Embakasi, Tasia. We do make everything by our hands. Everything you see here is handmade by Kenyans. So guys, I would ask you to help me go to the fashion week in London. I would really appreciate it. My work, it ended up the biggest runways in this world. Yeah, to showcase my work out there. So my baby, utaipata hapa kwa page yangu.
A glimmer of hope stands erect at the entrance of the National Archives, an assurance to many that despite the hard times, there is hope, hope for a better tomorrow.
Coronavirus imeleta shida kwa vijana na kwa kila mtu, sana sana kiuchumi. Mapato imerudi chini, Alafu kitu kingine pia, unajua kuna wenye wajiwezi, na kwa saizi pia wenye hii sasa corona imekuja wameendelea kuadhirika zaidi. Lakini kwangu mimi pia, mimi niko na familia na niko na watoto kama 4. Mmoja ako form 3, mwingine ako class 7, mwingine ako class 3. So shida ya mapato pia ni shida. Kutafutia riziki imekuwa changamoto kwangu.
Hii corona venye ilini affect ni job, as in customers wamepungua, ndika hizo, but michoro za ma-artist kopojo inaonyesha unaweza soma ukiwa home kwa students hivyo.
Mimi ni content developer na pia huwa nafanya graphic design. Naweza sema hii COVID kuna vile imeaffect a lot of things. First, kuna vile imeaffect flow ya watu, vile customers wenye nilikuwa nao, at least kuna vile biashara iendi vile ilikuwa inaenda initially. Alafu at the same time kuna vile imeaffect watu like socially, kuna vile watu kuinteract inakuwa ngumu sana. So at least naona wasanii vile wanafanya like vile wanafanya kuentertain watu, at least wana bring hiyo, as in wanajaribu ku mitigate hiyo boredom, at least wanajaribu as in kumotivate watu. At the same time wanajaribu kueducate watu kuhusu vile wanaweza avoid kupata hii disease. At the same time vile wanaweza cope na stress zao.
The flip side of the pandemic is that today, more than ever, the human race has to work together without discrimination to bring this pandemic to an end. Artists here in Nairobi, through the installation, are showing Kenyans how resilient we can be in adversity.
These artworks is all about being resilient as artists, and of course as Nairobians and as Kenyans. So the artists express themselves, just in what sense are they being resilient at this particular time. So they were able to work on it for over 2 weeks, and then we managed to put them together to create one big canvas of all these expressions by 48 artists.
Michael Nyerere is one of the artists who contributed a piece of art for this project. Like the rest of the artists, he believes that no matter how squalid things can get, we always find a way out.
The inspiration that I did the other one is just to show as much as tuko humans, bado tuko vile si tuko. So I did a monotone of red just to show hata kama our surrounding is very red in a show color, which is very hot, but I just show even if we are still human, hata kama surrounding yetu bado iko in a very crisis that way. Yeah.
The influence that artists have over their followers is undisputed. With the studios, galleries and museums close to the internet, and installations such as these are creative and big avenues to get the word out and keep the creativity going.
Wasanii unajua wako na a lot of influence over people. So nimeona wasee wanafanya kama live shows, especially DJs, na pia wasee kama unapata musicians wametoa mangoma. So na realize that they are also using their platforms for the betterment of the country. So it's a very nice way of helping our country in terms of passing the message. Juu kuna wa following wako nayo kubwa sana. So nimeona like wamejitolea sana na it's good job.
If you look at the artworks, you'll see that there is a man, I don't know if he's a hawker, carrying, his things going to sell. But at the same time, he has a mask on. Basically, that's the new normal. As in, as much as we have our livelihoods that we need to make sure that it's ongoing, we have to make sure that we follow the government guidelines.
These artists understand deeply that there is something that everyone can relate on this wall, and that's why they are not stopping. The resilience is evident, and they vow not to stop the campaign anytime soon.
The way forward, as I mentioned earlier, the stimulus package that the government had given out, I just wish now they could do more. As I said earlier, we need more spaces, more public space that artists can be able to go and create. We need galleries. If anything, the government should put up a national gallery that the artists can be able to go and put up their artwork. Even if it's not building one, if they can come up with a building, government has enough buildings in Nairobi, just something to start off. So those are some of the things that I strongly feel that the government, of course, should.
Nichukulie pensani ndani ya matatu. Yaani mtu mzima na miaka yake ile miaka yote. Mtu ajikuwa kaandika noti peke yake. Kusema gani itasaidia gani? Nini nakusaidia nini? Nauliza. Ni bwana. Chukia.
Next on.
Siku tatu umetafuta hizo pesa na umeniletea. Siku tatu zinatoa wapi ile mtatu? Mimi sitaki kujua. Kama mfanye nini? Hili siwezi mgongo kukariki. Ndio mgongo. Alafu sasa ndio chamba. Ndio mgongo.
Next on.
Matumizi mabaya ya ofisi, hasa zaidi ofisi za umma.
Na vile vitu vya mtoto vile vya akijisaidia vile pampers vile. Pampers. Mchukulie. Kila soko isiji iko wapi? Yeye mtoko hata ndio marikiti kwa wapi? Hizi jina marikiti kwa wapi? Na leo jaipitia.
Anawacha kazi ya kupeleka file, anatumwa supermarket.
Yaani this. Hii kitu kinaharibu jina ya kampuni. This is what we call design. Kwa takataka kwa hapo. Yaani ndani tunaelewa hapo ndio panguze pangara kabisa. Sekta yangu ni tarakilishi.
Huo ni ungwana kweli.
This weekend on KBC Channel 1.
Are you going to sit here like this through the lesson?
Why not? If you're that disturbed, plug yourself somewhere else.
Nadia, why are you this dirty? You know, a lady should never be seen like this. Now I believe that TikTok. Ladies in this class have completely nothing to offer.
Who goes to a restaurant, an entertainment joint to drink water?
What is wrong with your small head? Haven't you heard about the test and the preferences?
You guys are just a bunch of losers. What sort of entertainment is this?
Does this song sound familiar? In the morning, Come on, what are you talking about? That's like a sing-along, yeah? Who doesn't remember that?
Classmates,
Every Saturday on KBC.
this weekend on KBC Channel 1.
Mwanangu ni gajeni. Kwa gavana kunataka mahesabu. Kunataka mahesabu. Kwa sababu yule lazima ujue wale askari ni wangapi pale ndani ndio wanamlinda.
Sasa ndio ushaanza uoga. Jeshi gani anakuwa namna hiyo?
Kwa nini kazi?
Nadhani sote tunaelewa kilichotuleta.
Next on
Jeshi sasa ndugu za nini kama wanishtua hapa?
Siku tatu umetafuta hizo pesa na umeniletea.
Siku tatu zinatoa wapi ile mtatu?
Mimi sitaki kujua.
Kama mfanye nini? Hili siwezi mtaka kukariki.
Ndio mgongo. Alafu sasa ndio shamba. Ndio mgongo.
Yeah!
That's all right. I just wanted to.
Oh, okay.
I didn't want to get so much into it.
Yes.
Yeah, ideally, being my in-law, I would want you to get this office. Unfortunately, it doesn't work that way. You have to, you have to get it by, by right.
Competence, yes.
Yeah, because there are constitutional imperatives that this commission has to abide by. We are accountable to the people of Kenya. So I'll still ask you the hard questions. Now. And I picked from Commissioner Warsame. When you were asking some questions, then you said you're not comfortable answering that because the debate is out there, which I understand where you're coming from. But it got me thinking, when judges are making decisions, and if you become a Chief Justice, you'll be in the Supreme Court, and you'll be making decisions, where is the place for public opinions in terms of societal influences on the judges, even as they make decisions, because they are ultimately human beings. I would want to understand from you, where is the place of these influences behind closed doors? Because you see, right now you can say easily, I will not answer that, I'm uncomfortable, but there'll be those times when you have to make a decision and you are influenced by public opinion somewhat. Where is the place for that?
Yes, thank you very much, Commissioner. When a judge has to be called upon to make a decision, maybe basing on public opinion, one thing that comes to my mind is, for example, there is a trial of some serious criminal offense. I'm just giving an example. And there are people outside there screaming with machetes and rongos and all that, waiting to kill this person. I think then it will behove upon the judicial officer to bring in a custodial sentence to ensure this person is not killed. In fact, that is saving the judiciary another trial if it were.
Yeah, but I'm looking at the general issues. Say, for instance, like the issues of gayism, issues of, say, like, you know, even sometimes when election disputes or an issue that where the country is divided on an opinion, maybe even religious issues and all that. And you see, the thing is, why I'm asking this, these judges will be in chamas, they'll be going to, you know, weddings with people, they are, you know, they go to schools where they are interacting with people. So discussions do happen.
Yes.
So people, and you see, judges are not, you know, as it were, you know, excluded from society. So I'm just trying to understand as they come up with the decisions, which you'll be part of them if you become the Chief Justice, and you're making determination on serious jurisprudential issues that affect members of the public. So I'm just wondering, and then again, they're out there discussing, when they're hearing, and they all sometimes they're participating in those discussions. So when it comes to ultimately making the decision,
yes,
I'm still trying to understand from you, where do you place the influence of those public opinions?
Thank you very much. I've gotten you very rightly, correctly. Yes, in
summary.
Yes. Really, for the judge, you don't have to take your decisions because of public opinion. Doesn't play a role. You've taken an oath of office to impartially and integrity-wise, competent-wise, decide on an issue without that influence. In other words, what I mean is we don't have a place for that. As a judge, you must be integral. You make your decisions as per the law that gives you the powers to do that, per the Constitution, the statutes and all that.
Okay. Now, there's somebody called William Rehnquist. He was an Associate Justice of Supreme Court of U.S. for 15 years. Then in 1986, on the eve, he became a Chief Justice. Now, on the eve of becoming the Chief Justice, he made a lecture at Suffolk University Law School on constitutional law and public opinion. Let me read for you what he said. Then you tell me whether you can comment on that. The judges of any court of last resort, such as the Supreme Court of the United States, work in an insulated atmosphere in their courthouse, where they sit on the bench hearing oral arguments or sit in their chambers writing opinions. That's what he said. Then he further went on to say that, but these same judges go home at night and read the newspapers or watch the evening news on television. They talk to their family and friends about current events. Somewhere out there beyond the walls of the courthouse run currents and tides of public opinion which lap at the courthouse door. Now, if you go by what you just told me, this is a Supreme Court judge who now became a Chief Justice of the Supreme Court of the U.S. Mm-hmm. What is your position? Because it seems to be contradicting what you have just said.
Yes, my position will still remain the same because as a judge, really, you can be influenced by so many things, especially surrounding you and all that. The people you are with, the families you still go back to in the evening after work. You should be able to put those issues behind your back and look at your matter in a very objective manner as you comply with the law and also the ethics that pertains to your office.
Okay, now let's leave that subject. We move now to something else, which is I need to match your skills in accordance with the law with the job that you are seeking. Because at the end of the day, we have to be absolutely sure. You see what happened is that with the decision of Justice Odunga, if you meet the minimum qualifications, we must shortlist you. But at the time of the interview, we must now interrogate further and see whether indeed the qualifications match or not, which is why I will be coming to these questions. Now, my starting point, Article 166, Sub-Article 3, A, B, and C is the one that now stipulates the qualifications of of a Chief Justice. What are these qualifications? Let's start from there.
The qualifications is 15 years practice, academician, 15 years, if you, yes, that is for me. For me, it's 15 years in legal practice.
No.
And I have 25 years more than.
No, that's,
yes.
You see, A says 15 years experience as a superior court judge. B, 15 years as a distinguished scholar,
yes.
Or academic, whatever you want to call it, or legal practitioner, or judicial experience, that 15 years, or experience in relevant legal field, that is B. Then C, aggregate of either A and B, aggregate of 15, isn't it?
Yes.
But now, so you've rightly said that yours is a B.
Yes.
Distinguished legal practitioner.
Yes.
But see, of course, all lawyers who have done 15 years and above will say they are qualified, which is why the Constitution was very clear about distinguished, isn't it? That's where I want us to come to. Now, let's ask ourselves the definition of the word distinguished. If you look at Oxford's English dictionary, how it defines distinguished, it will say very successful, authoritative, right? Very successful.
Yes.
Authoritative. It moves that way, in terms of defining. That is now on Article 166, Sub-Article 3. Now, I want to find out, let us look at now your CV. We look for very successful, authoritative, commanding great respect. In fact, that's what Oxford Dictionary says. Very successful, authoritative, commanding great respect.
Yes.
I would imagine now that is, in the context of your peers, right? So I want you to tell me, in terms of litigation, because you are more of a litigator, you've said that you go to court and you also draw agreements and all that, but that's not the one I'm interested in. Give me cases that you've handled that have had great jurisprudential impact, right? Great jurisprudential impact, even widely reported, that now would make us in the legal profession say that yes, Alice Yano is a distinguished legal practitioner. So that now you can qualify for this position.
Yes, Commissioner. Thank you very much for that question. In fact, I've really been looking forward to it. I've been asked elsewhere, not here only, that when you are asked about this distinguished legal practitioner, what will you bring in? Is it a matter of cases that have been able to present before a court of law, decided, and then the same are put in the public limelight for purposes of Kenyan saying, wow, this is a distinguished legal litigator? No. When I look at it, for me, it's an all-round, holistic way of looking at the person from all that pertains to that person in terms of the other experiences she has brought on board, in terms of the law firm. And when I want to talk about the law firm, all the law firms are not the same. There are those law firms that strictly take only some limbo of other legal matters and not others. Others do more work that may not be known And it is work that has moved and pushed communities from point A to point B and really has assisted so many Kenyans to get justice. For example, I've given some few case laws. There is one on maendeleo ya wanawake that dealt with the gender issue. Sorry, I was not able to annex it, though it is reported. Leaving that alone, I've given you my practice, not only being here. Why did I choose to go to Kajiado? That's the first question. I've been in Nairobi for so long, and in fact, the first issue I started with is to say thank you because you relinquished your office for me when I started in Nairobi. And I practiced in Nairobi for more than 10 years. After practicing from Nairobi, with the time I realized most of the clientele that used to frequent my office were poor women who could not even afford fare from their places to come to Kitengela, and most of them were from Masaini. They've been disinherited. Apart from that, of course, all negative issues that pertains to women. And I thought the best that I could do for them is to take justice closer to them. And taking justice closer to them does not mean I just took the office there. No. I took also the practice of law there. So that we've dealt with so many issues of successions that are not being felt.
I hear you.
Yes.
I'm not, forgive me, I'm not underestimating what you're doing. But remember, this is the Chief Justice, the Supreme Court President. Now, and we are very many of us, we are thousands of advocates. So whoever we pick, we must be able to, that's why I said by saying about being accountable to the public. We must be able to show that from all these others, Alice Yano is distinguished, which is still why I'm asking specifically, let's go to specifics, so that we don't go into, generalities. If, and again in the interest of time, you could just tell me very quickly, this is, this is what I did, very high impact, renowned, widely reported, so that we're able to move on now to the next question.
Yes.
Whatever it is, if you feel it's not legal cases, anything else that has contributed immensely in an impactful manner, so to speak, in legal jurisprudence, because that's what you'll be doing in the Supreme Court as Chief Justice Alice Yano.
Yes, you're taking me back to the same issue. So that is it to interpret that part to mean that the candidates must have had decisions emanating from the Supreme Court? Is that what I'm trying to understand? That the impact is so much that it should come from a court that, yes, this is an appeal court judgment. Is it a Supreme Court judgment that Alice Yano has been able to participate in? That's what you're asking. For Supreme Court, no.
Cases.
I've not done Supreme Court.
Okay.
But Court of Appeal, I've done several. And one that comes to my mind anytime I'm asked about it is the maendeleo ya wanawake case, where women were pitted against each other. One wanted to still have kano maendeleo ya wanawake existing as it were, and the other group wanted maendeleo wanawake independent. And we were for this group that says, let us have an independent maendeleo ya wanawake and exercise it from political connotations. And we were able to succeed in the Court of Appeal, and we were able to now even move ahead and make kano maendeleo wanawake own this house called Maendeleo House in Nairobi.
Let me maybe move a step further on that question. When you look back, you have the advantage of being the 10th candidate, so to speak, in these interviews. We have had 9 others. Now, let me distill these candidates before I can pose my question to you. The first candidate, a Superior Court judge of many years' experience, having practiced also for many years, also moved to the corporate corporation. The second candidate was, so to speak, a distinguished academic. The third candidate was a judge of Court of Appeal, who also practiced for many years before that. The fourth candidate, I think, was a judge of the Industrial Court for, I think, 10 years plus, if I'm not wrong. The fifth candidate, a senior counsel, distinguished in law practice and previously a high-profile prosecutor. The sixth candidate was a former president of Industrial Court in Lesotho, senior crown counsel, now, practice in East African Community, Federation of Employers, Kenya Employers, now a distinguished Industrial Court judge, ELRC, so to speak. The seventh one is a very serious advocate who has done all manner of groundbreaking cases in the Republic of Kenya. The eighth one, a judge of Court of Appeal who literally has cut his teeth here for 34 years. The ninth one, a professor with the 2 doctorates, the one of yesterday, yes. Doctor, Professor. Now here you are.
Yes.
Now tell me why you are not all those others that I've just given you.
Yes.
Why it has to be you?
As I told you earlier, I've been running a law firm since 1996 to present. I've done so many matters. Maybe most of them may not be in the public limelight. But for me, even representing or doing ADR or doing conveyancing and all that, that is still part of the law. So I've done as much as I've done, but maybe I've not been out there in the limelight to be told, to be heard, that Yano today appeared before this court and has done ABCD. No. I think, and then the experience I have, not only in that, my experience in CKRC, that is a precursor to this constitution. If it were not for the bombers draft, we may not be enjoying this constitution. And that was a very, very rigorous work that actually, to my belief, has really prepared me in so many other undertakings that I've done. Because we did extensive civic education, collection of views, collation of the same, sitting down, coming up with a draft, engaging experts, benchmarking. In fact, there's something else I learned, Madam Chair, when you were asking me about this leadership. There's, adding on to what I'm saying, is benchmarking. Like now when we benchmark in Rwanda, we did, we went to what we call Gachacha courts. Gachacha courts is a way of doing ADR, that is restoration, restoring a person who had committed a crime back to the community, because Tutsis and Hutus had to live together.
I hear you, my sister.
And looking at that, it was a way eye-opener, because then it is not only meting out sentences.
My sister, I hear you, but you know, there are so many lawyers who have also served in these commissions, in other bodies, and all that. But you see, that alone does not make them distinguished and fall into the category of those who can ascend to the Chief Justice. But again, with the rider, I'm not underestimating what you've done. You've done a lot. You know, just the question of whether now, you know, it puts you a notch higher, you know, to occupy that high seat. Now let me move to my last question. You see, you said, when I heard you, you asked by the chair, which is now what I'm following up, is that why you feel that you can be the Chief Justice and why you applied. And you said you work hard. If I picked those answers, you work hard, you know, and you'd want to contribute to to give back to the public, so to speak, you know. But I got wondering, there are so many ways you can give back to public. In fact, you've given already. You know, even what you said about that empowerment, the women and all that, that's already, you're giving back to the public. There are so many ways of doing it. But why then the Chief Justice? Because you can still give back to the public in many other ways, right? Without necessarily coming for the Chief Justice position, because that in itself is not a reason for us to hand over this position to you. So I still want to know, specific to the Chief Justice, why did you apply? What is it that you want to realize in that office? Because ultimately, that's what will determine to us why we have to pick whoever we pick among the 10 candidates as we account back to the public. Why specifically this position of Chief Justice?
Thank you very much. Adding on to what I'd said, yes, giving back to the society, I can do it in different other ways. There's also the experience as per my CV, and I've already been able to explain some of the other reasons. I've already also tabled my leadership qualities, for which I know I can be a very good leader by virtue of the experiences I've had. And all that partakes to being a Chief Justice. I've been a leader. From day one, I told you how by the time I was barely 21, I was a whole headmistress of a secondary school. The university, I was a student leader and leader to the Senate. CKRC, I was the deputy to the finance manager, and CKRC was so mammoth. Actually, it was more or less like the commission. And I'm telling you, human resource. We talk about it more or less like the judiciary. It was in all parts of the country. We had coordinators with the staff in each and every district then. And it behoved upon the finance and administration committee of the judiciary to ensure the smooth running of all the operations of CKRC. And we were able to do it very, very well, using all our skills to ensure CKRC brought in the draft constitution.
Okay. What you did, you just described the CRJ's work, you know, the administration. But I wish you well. Thank you so much.
Thank you very much, Commissioner General. Thank you, Council. It's now the turn for our Attorney General, Kihara Kariuki, to ask his questions.
Thank you very much, Madam Chair. Learned Counsel, good afternoon.
Good afternoon, AJ.
Learned Counsel, you've outlined your experience over the last 25 years of legal practice in these courts. And you set forth some of the challenges that you have experienced or encountered, with particular reference to the expeditious disposal of cases. And you also offered some solutions through the use of ICT, tracking, etc.
Yes.
Are there any other aspects, are there any other problems or challenges that you have experienced in the courts that you would like to share with us, apart from those relating to the expeditious disposal of cases? What else have you encountered? What other problems do you see in the judiciary?
If I go to where Commissioner AG, is it that you want me to answer on, to provide an answer on what problems we've faced, or what problems the judiciary has faced?
No. What problems have you, as counsel, practicing in these courts, have you faced? And which you think the judiciary ought to rectify?
Thank you very much. AG. Yes, as a practitioner, yes?
Say 3.
3. As a practitioner in the courts, the problem that really was really the issue that really made our practice difficult is the disappearance of files. Times you come to court, you're ready, then from nowhere your file cannot be seen.
That's to do with the expeditious disposal of cases. If the file is missing, it delays your filing of whatever application you wish to make. It delays, etc.
Yes.
Apart from that line of challenges, are there any others that you have experienced as a consumer of the services of the judiciary?
Oh yes, there is the usual times you appear before a magistrate or a judge and the treatment you get is not very comforting. You feel there's some bit of, it could be a disconnect between you and the judicial officer or the magistrate, and you feel you're not really, it's like you're not welcomed in that particular court. You know what it does to the confidence of that advocate. You feel you even presenting yourself could be very, very difficult.
Thank you, that's one. Another?
From the experience also is, I don't know now whether the infrastructure in Milimani has improved, because sometimes back we even wrote a letter. It was to do with the ramps. Small things to put, because we were saying kindly put for us the Mabati.
So there are problems to do with the infrastructure in the judiciary. That's 2, thank you.
Infrastructure. And the other thing really is perception. But we've learned to live with it. When somebody files a case, and within a short while they're getting this and everything is hard, it's like, could you have been there to bribe the magistrate, or could you have given out something, that kind of thing. So it also makes you feel, there's some suspicion surrounding, which is wrong.
All right, those 3. Please address us on each as to how you, as Chief Justice, would offer remedial measures.
For the attitude, really, for me, it's something that we build some sense of understanding and knowing the kind of environment. All of us are officers of the court, the kind of environment we work in. We can be able, maybe once in a while, put these people together. We don't have to have, throughout we have maybe CLE for advocates only, we have JLE for judges only, or magistrates. Personally, I feel there should be a way we can mix in a way that we get to, not really in terms of seminars or workshops and all that. We can create something and put maybe practicing advocates and the judges and magistrates together. It will clear that discussion, that openness. As for infrastructure, I think it's something that, to me, I'm not quite sure. If it has been put, then that is good. That is a matter of ensuring that proper how to access courts. Simple things like hygiene can be, it's something that can be corrected very easily.
Learned Counsel, you've been practicing these courts all over the country for the last 25 years. You must have some idea of what our courts are in terms of, to use your words, hygiene, for instance. You're now Chief Justice. You have the opportunity to rectify whatever you have seen that is not good. How would you go about it?
Of of course, working through the administration structure, ensure that probably reasonable toilet facilities are there. Water actually, I think, Commissioner, you're aware, Milimani, we've had issues of water for a long, long time. And those are things that can be addressed. I don't think it's a matter that cannot be addressed. And then the issue of bribery, it cuts across. And it's not only the advocate or the judicial officer. How can we deal with that? To me, vibrant communication is key.
Can we be a little more specific, learned counsel? Use the wider word of corruption. What are your perceptions about corruption in the judiciary?
Yes, for me, corruption in the judiciary really tangible evidence that corruption, I've seen corruption in the judiciary, I'll be lying if I said that. But there's that perception. That perception, because how can Mr. X today come to court and he gets a hearing date, maybe for May, June, and here Ms. P comes to court and given a date next year. So those are things that, makes the party things. Could there have been something that had been done? How could have this judgment been delivered within such a short notice as against judgments that have been lying with a magistrate or a judge for a long, long time?
Yes.
Yes.
So, yes, those are the manifestations of that perception.
Exactly. So you see, it is through some of these omissions that parties get a bit jittery that there could be some corruption somewhere. A file disappears for ages. What is happening? Or at times a file maybe is awaiting, let's say judgment has been given or rulings have been given, and those files are not released immediately to the registry. So those are the perceptions.
And these perceptions, learned counsel,
yes,
have led the public to lack confidence in the judiciary.
It's true.
And this is now yourself as the Chief Justice. What steps, what measures are you going to take to restore that public confidence, to remove these perceptions, to make the general public believe that the judiciary is not corrupt?
First and foremost is communication. There is so much that the judiciary has done that is good, but you see, to be shrouded with that or veiled with that veil of corruption, really let it go out that the judiciary is not as corrupt.
How would you do that communication?
Communication, you can do the annual communication. I see there's a structure to do annual communication, though that is not enough. Can a website be created for the public to be knowing what is happening? Is it like using Service Way? Can it be communicated to the public what the judiciary is doing? The other issue is to work on the backlog, because that is where also this perception comes from. How comes this matter has taken so long? Is it because there is somebody who's been seen to sit on the file? Actually, the term they use is to sit on the file. But then you find maybe the judiciary may not have that empowerment to process the cases as fast as they would wish. Like the case example I gave of what has made backlog of judiciary to be seen as not working.
Yes.
Lack of enough judicial officers. We've talked about the 40 judges. Maybe we talk about also finances, because we don't have adequate finances, then how do we even work on issues of ICT? so that we can be able to use ICT to ensure that this case backlog is dealt with. And I know one thing, if the public see or get a feel that there is a movement towards clearing these cases, then there'll be some sense of comfort, some sense of confidence in the judiciary.
Who was Chief Justice when you started practicing law? Can you recall? 25 years ago? All right, maybe you can't, but...
I was sworn in by Coker.
Justice Coker. Who came after
Coker.
Justice Coker?
Yes, but I can't...
Then you've had Justice Gisheru, you've had Chief Justice William Mutunga, you've had Chief Justice David Maraga, correct?
Yes.
So that, say, for instance, that's 4 honorable Chief Justices during that time. And all of them, without exception, have encountered this problem of corruption.
Yes.
Correct?
Yes.
What's going to make you different? What are you going to do to crack this problem?
Corruption actually has become the cancer of the society. Everything nowadays is when even something small going wrong, corruption, the term corruption comes in. So we really need to address this, and we must address this in a very logical, open manner. If to address this will mean looking inside the judiciary and do, I can't call it investigations, do some audit. Let us find out what is it that brings this. If actually a member or no, a judicial officer or even staff is found to have engaged in one form or the other in corruption issues, then that person should face the law or the procedure that leads to that is disciplinary procedure. The other thing is, when I look also inside the judiciary, what do you think that, what comes to my mind is, what could have made maybe a staff not to work on a file or even to bring the file to the attention of the magistrate or the judge? And I want to equate it to, like my law firm. When you find a worker not working, what could be the problem? Then what comes to my mind is, can we build on the human capacity? Train train the members of the judiciary, train the judicial staff. If we can also move towards even awarding them, motivate them, so that they know we work together as a family for purposes of delivering sound and good justice. If you did that and things seem to move from within, then that is good. Then I've also mentioned what is it, this perception of the outside corruption. If it is inside, yes, and it is there, let disciplinary action take place. There's nothing much you can do with the perception outside there. The most that one can do, and I believe, is communication. Communicate to the members of the public. Let the members of the public see that there is delivery of justice. Case backlog is done now, they are done away with. Okay, we may not say that we are doing away with it.
All right.
But something should be seen to be done.
Thank you very much, Learned Counsel. My last question to you, if you would be so pleased as to answer it. I presume you know that the judiciary has a code of conduct and ethics. And under that, sexual harassment is prohibited. You're sitting in your office as the Chief Justice, and in storms a lady member of your staff, and relates how a male judge has been persistently sexually harassing them. And you're persuaded, after listening to this litany, that there is indeed justifiable grounds for taking action. This lady then tells you that she is going to call a press conference and tell the general public of what she has been going through. What would you do, Learned Counsel, as Chief Justice in those circumstances?
Yes, I want to appreciate that this is can bring in a very difficult position. Because here is a code of conduct spelling what should be done when an offense of that nature arises. Which means then it must be taken for disciplinary action. But then here, again, is a party who would want to call a press conference. I think really calling for the press conference, in my mind, is it trying to solve this problem or escalate it? My best is to advise the person who's been harassed that let us exhaust what we call in the code of conduct. It may not help us so much. Okay, it may help in what we call instant mob justice. But to me, instant mob justice has never been justice at all. So can we follow the code of conduct and forget about the press conference? I think that's my take.
But Learned Counsel, this lady is crying. She's very persistent.
Yes.
She's hurting. And you're there as Chief Justice. And the minute she walks out of that door and goes to the press, why would you stop her from going to the press? When we talk about transparency, what would be the reasoning behind your wanting not to have this matter exposed outside?
Commissioner, when I look at it really, I can understand because I look at the emotions that go with it at that particular time. Maybe we have to put some stopgap measure, take her somewhere, sit with her, try to cool her down, instead of having her immediately go to the press, because the press could be either way. Unlike the code of conduct that if we followed strictly, it will give us a reasonable, impartial, fair product. The problem with the press, and I'll advise her, that the problem with the press is that at the end of the day, they would even bring in other circumstances, extraneous to even what actually happened or what the lady is explaining. So that we see the objective of leaving this route, we deal with this route.
I am most grateful, Learned Counsel, for you having answered these questions. Madam Chair, I will have nothing more to say.
Thank you very much.
Thank you very much, AG. Thank you, Counsel. Now is the turn of Commissioner Gishohi to continue with the questions. Commissioner.
Thank you, Chair. Council, good afternoon.
Good afternoon, Commissioner.
Good. I really appreciate the 26 years you have served, and I'm sure if you get this position, the Commission will benefit. I want us to focus on your leadership qualities that you have mentioned, and I want us to focus very specifically to the Commission. And I want us to focus on the Commission, you as a chairperson of the Commission. I know you have worked in other commissions, and I hope you can be able to get something that can help us from your leadership areas. If you are to get this position, two things. I'd like you to develop a robust, responsive, coherent commission. Responsive commission. Will you share with the commission two things that you will do to ensure that this commission remains responsive and accountable? Two things.
Thank you very much, Commissioner. Two things that I'm looking at. One is the impact that this commission can do in terms of human resource capacity building for the judiciary through JTI.
Very good. Next one.
Next one is I would also want to look at the disciplinary procedure and how fast decisions could be arrived at via V.
Disciplinary procedures, I presume, under Article 168.
Yeah.
My question is how, the system, how will you do that? What do you introduce?
Okay, for training, which I know is core to this commission, the first thing is evaluate and find out how far we have gone. And from there is to find out the best way to make the commission robust in terms of training. What comes to my mind, which is more of a hypothesis because I've not been here, is we should go towards having a training institute of the nature of maybe government training institute, where we can be able not only to conduct training for our own judicial officers, but also we can be able to offer services, that is, or use the infrastructure, give it out or lease it out to outsiders and make money for the commission.
Okay, we have one GTI.
GTIs, that's what I'm talking about. And I don't know whether I'm correct. I hear it's being sold or there's a problem, but if that is the case, then it is be upon the commission to immediately acquire its own training grounds for purposes of ensuring proper...
Let's move on. As the chair of the commission,
yes,
I want to see the demarcation between the commission and the management. And my question is, how will you ensure that the commission maintains an oversight law on the management without necessarily micromanaging the management? One way that you do that, to make sure that the commission maintains an effective oversight law on management without necessarily micromanaging what they are doing. What tools do you have? Yes.
Yes, oversight is a real major role, so that at least you ensure that whatever needs to be done is done, but done within the ambit of ensuring if it is management, management is done. Well, why I'm saying this is, if you look at, because the commission, when it comes to management, more or less, most of the functions, and especially looking at issues of funds and all that, is under the realm of the CRJ. The CRJ has our own directorate to deal with that. But then what happens is, at the end of the day, you must get audit from the CRJ brought to the commission so that you can be able...
Let's call that reports. You'll be able to ask for reports from the management. Yes. Another one?
I've seen also, I think I must have seen from a document I was glossing, is you're also keen on falling on issues of backlog of cases.
Council, I say that I'm focusing on your role as a chairperson of this commission.
Yes.
You'll be among the 11, first among equals. The buck will stop with you. You have a responsibility to play an oversight role on what they are doing. I'm looking for a structure that you'll be able to introduce in the commission to make sure that you maintain an oversight role on what they are doing. Maybe you can talk about monitoring? You have an idea about monitoring issues, monitoring systems?
Yes, monitoring and evaluation.
Okay.
Yes.
Madam Chair, do allow me to proceed on to the next part. Council, I want you to focus on Article 232, 1 and 2 of the Constitution, and this article talks about principles and the values of public service that bind all state organs, including the judiciary. I would like you to pick 2 of those values of your choice and share with the Commission how you will be able to promote and enhance those values within the service. Just pick 2.
Okay. One is integrity.
Integrity. And I want you to focus to Article 232, not Article 10. 232, 1 and 2, principles and values of public service. Let's take integrity, yes?
Fairness.
Fairness.
Impartiality. Equality.
So pick 2 of those and share with us, share with the Commission, how you are going to promote. Question is how you will be able to promote those values within the service or within the judicial service. How you promote and enhance those principles.
Yes, when I look at issues of integrity, integrity is very core to a commission like this because you're not only managing issues to do with the judiciary, you're also the first stop shop when it comes to Wanjiko crying outside there. If it is integrity, we must rise above, not only to be seen, to be above or to be clean, but also we must practice it, whether in or outside. The other issue I look at also is when we look at Judicial Service Commission and especially VRV issues to do with disciplinary, then are we looking at ourselves or, of course, supposing I became the chairperson, as being fairly able to give fair, reasonable rulings when it comes to disciplining members of staff?
Okay.
Yes.
I was looking for something like a framework that you'll be able to introduce to enhance those. So in case you are familiar with any framework that talks about integrity, fairness, impartiality, equity.
I think you must be having some in place. But if it is a matter of introducing, then it is about the commission sitting and coming up with one.
Earlier on, I talked about devolution, about the county government, which is very good. I have been able to go to Kenya Marakwet, I don't know what they do. But my interest is on a framework that you would be able to introduce, that you'll be able to interface judiciary and the county governments in totality. A framework that you would be able to introduce, not singularly towards one county, but the one that you'll be able to encompass all the county governments. What kind of a framework would you be able to recommend in terms of the judiciary and engaging those county governments?
Yes, the framework I would want to look at is a framework that brings in a link between the judiciary and the county governments, so that we can be able to benefit from those links. The way I'd put it in terms of communication, communicating to the lowest person in the ground, in terms of maybe getting land to put up our infrastructure, and so on and so forth and so forth, or even, yes, so that kind of framework, or once we've come up with those points, what is it that we want to do with the county governments, then that will inform the framework that we're going to come up with.
Okay. In terms of engagement, you talked about engagement with the other arms of government. Maybe you will share with us value that will be added to that engagement with the specific units within that engagement. And you could share with us those arms of government that you will be able to engage and the value that is going to be added.
Okay. When you talk about the arms of the government, I'm looking at the other two. That is the legislature, and the executive.
Mm-hmm.
And what value are we looking for by engaging with them? As I said earlier, is really we cannot operate on our own. We cannot operate in a vacuum. We must operate interdependently with the other three arms of government. Why? It's because all of us are serving the same entity, that is Wanjiko, the common Mwananchi.
Okay.
They ceded power to us to work for them.
Let's focus on Parliament.
So, Parliament, yes.
Yes, share with us in terms of Parliament. What areas are you looking for? What areas are organs within the Parliament that should be engaging?
Yes, for Parliament, for purposes of maybe funding.
Funding?
Yes, we can look at judicial, legal affairs committee, and also the budget committee in Parliament. That is if we're looking for money. If it is at the executive, we may be able to engage the treasury.
Okay, treasury, specific treasury? Maybe you are the chairperson of the commission.
To me, cabinet secretary. Yes.
What discussions will you be having with the CS treasury as a chairperson of the commission?
Yes, the discussions probably that could be coming up is maybe two-way prong. I would look at, if I'm asked, though I am not so sure, but I would look at, and I've heard some of the candidates say that the judiciary fund has not been operationalized. And also I would look at the issue of maybe getting more funding from the consolidated fund. Is that a system I could follow? That is the channel I could go through. And also if funds are withheld, those are the issues I should be bringing to the cabinet secretary's table and how we can go about.
Okay. Which other office within the executive you find time to engage with as a chairperson of the commission, apart from the CS National Treasury?
Yes, the office of the president.
I was the president?
Yes.
In what areas?
Like the issue of the non-swearing in of the 40 judges. Those are the issues also we should be looking at from that point of view, that we can be able to negotiate, focus, maybe agree and have the president swear these 40 judges.
You have answered this question here alone from my colleagues, but I still have to ask it and get it from you. To enhance and deepen customer service, citizens who are main clients, would you share with us one or two areas that you would be able to deepen our relationship in terms of our customers, service to them?
Okay. Yes. One thing I should do is thank the judiciary for what they've done within, I think, we've been seeing it last almost 2-3 years. Introduction of the customer service desk in most of these locals. And it has worked very well, and I can comfortably give the example of Kajiado locals. You'll find that I think they know what they're supposed to be doing. They're trained well, and I wish the same can be replicated elsewhere, because I remember I went to Kitale, but you could find that the customer care desk was not as effective. So maybe train the ones who run the customer care desk.
Okay, customer training.
Yes.
What else?
And also communication. Communication is key in all this.
Okay.
Yes.
Thank you, Council. Thank you, Chair.
Thank you very much, Commissioner Gishohi. Thank you, Council, for those answers. I will now request Commissioner Felix Koskei to ask his questions. Commissioner.
Thank you, Chair. Good afternoon, Wakili.
Good afternoon, sir.
Yeah, you've practiced for 25 years.
Yes, Commissioner.
In these corridors of justice.
Yes, Commissioner.
From the lowest court to the Court of Appeal.
Yes.
And so you are one of those who, we can say, you understand. You know the challenges that are obtaining in judiciary and the successes, and you've seen over the years the improvements.
Very true.
Yeah. What areas, in your view, that if you come in as Chief Justice, you will quickly change, or you will work on immediately to improve efficiency and effectiveness in judiciary? Give us three. Is enough.
Thank you very much, Commissioner. The main one, the key one, that actually, if we can look at all the other problems, we find that there is a cross-cutting problem in all of them, and that is finance.
Yes.
For me, finance is very key. We have to get funding. And as I said earlier, there must be a way that we get funding. If it is not only maybe through the consolidated fund, maybe fundraising, there should be another serious way of ensuring that finance is gotten. We strengthen the directorate on funding, maybe even put, we used to call them proposal writers, to fundraising. We get a proposal writer to fundraising from some of these donors with specific instances where they're supposed to be funding. Because the other thing also, you can get funding from the donors. But you see some of them come, because I've worked also in the NGO world, and I know, they come with set minds on where they're going to fund. Supposing today they told you, we are going to fund this, and you know your priority is this. So we have to get specific person to sit and write proposals. If it is asking for finances, is for what prioritized benefit.
Yes, that is one.
The second one is ICT.
Yes.
We can't ignore that. Time has moved on. If we have to address the issue of case backlog, we have to go technology.
Yes.
So technology must be able to be embraced.
Yes.
And the other problem is, which I said also finance will cut through, also ICT will cut through, is backlog of cases. How do we reduce this burden? Backlog, as the AG had put it, it's been year in, year out. It's been there with us. Actually, it is something that has really tainted our names. It is a high time we cut on backlog of cases. If it is going ADR, we embrace ADR fully, and I'm happy Court and Next ADR systems are working. If it's bringing in traditional methods of doing it, let us do it. If it is getting more money, let's get more money to fund and push on with the matters that are pending before court.
Yeah, let us go back to finance. You've been hearing or seeing that there has been consistent budgetary cuts in judiciary. Every other year, you get it, it was around 30 billion, it is now about 17 billion.
Next on.
Siku tatu umetafuta hizo pesa na umeniletea. Siku tatu unatoa wapi ile tatu? Mimi sitaki kujua.
Kama mfanye nini? Mimi siwezi mbele kukaliki.
Ndio yangu dongo. Alafu sasa ndio chamba. Ndio yangu dongo.
بسم الله الرحمن الرحيم. السلام عليكم ورحمة الله تعالى وبركاته. الحمد لله رب العالمين، ثم الصلاة والسلام على حبيبنا وحبيب الرحمن محمد صلى الله عليه وسلم وعلى آله وأصحابه والتابعين وتابعيهم بإحسان إلى يوم الدين. أما بعد، فيا أيها المسلمون، أوصي نفسي وأوصيكم بتقوى الله عز وجل، فقد فاز المتقون. عباد الله، تمشكر الله سبحانه وتعالى ونعمة يا دين، تمشكر الله سبحانه وتعالى ونعمة يا عافية، تمشكر الله سبحانه وتعالى kwa neema zote ambazo kwamba ametuneemesha. Neema kubwa kubwa na neema ndogo zote ni za Allah subhanahu wa ta'ala. Wapendwa Waislamu, tukumbushana Mwenyezi Mungu subhanahu wa ta'ala atuambia kwenye Qur'anul Karim, fa idha quri'a al-Qur'anu fastami'u lahu wa ansitu la'allakum turhamun. Wa qala Allah subhanahu wa ta'ala, fa idha qara'ta al-Qur'ana fasta'idh billahi minash shaitanir rajim. A'udhu billahi minash shaitanir rajim. Bismillahir rahmanir rahim. وأقيموا الصلاة وآتوا الزكاة واركعوا مع الراكعين. وقال الله سبحانه وتعالى، حافظوا على الصلوات والصلاة الوسطى وقوموا لله قانتين. وقال الله سبحانه وتعالى، قد أفلح المؤمنون الذين هم في صلاتهم خاشعون. صدق الله العظيم. Wapendwa Waislamu, tumshukuru Allah subhanahu wa ta'ala kwa kuwa tuko katika 12 ama Ijumaa ya pili katika mwezi mtukufu wa Ramadhani. Lakini baadhi ya matatizo ambayo kwamba tumeona katika baadhi ya watu ni watu ambao kwamba wanafunga lakini hawaswali. Tunawakumbusha wale ambao kwamba hawaswali kwa kuwa swala baada ya shahada ndio nguzo muhimu zaidi, na ndio Allah subhanahu wa ta'ala atuambia kwenye Qur'anul Karim, wa aqimu salata, simamisheni swala. Nini maana kusimamisha swala? Ni maana uswali swala kwa nguzo zake, kwa sharuti zake, kwa wakati wake, kwa sababu watu wengi ambao kwamba wanaishi hasa miji kuu kama Nairobi na Mombasa na Kisumu na Nakuru, kwa sababu wanasema wao wako busy sana, wanafanya kazi maofisini, basi unakuta mtu haswali ya dhuhuri, haswali ya alasiri, anakimbia nyumbani magharibi ndio apate kufuturu. Akifika basi baadaye anaswali tarawehe 2. Tarawehe ya kwanza kulipa swala zote za mchana ambazo kwamba hajaziswali. Akisha kama atakuwa na nguvu ndio ataswali tarawehi nyingine. Mpendo wa Muislamu, hilo jambo halitakikani mbele ya Allah subhanahu wa ta'ala. Ndio anatuambia hafidhu ala salawat, hifadhini, zipeni heshima hizi swala kwa wakati wake, wassalati alwusta, na hasa swala ya wakati ya katikati ambao kwamba ni swalatul asri. Watu wengi ndio wanaikimbia, na utaona hiyo ndio swala watu hawezi kuswali wengine kwa sababu wanatakimbia nyumbani, yuko kwenye jam, na hiyo ndio swala tutafaa sana tujikaze kuiswali. Na Mwenyezi Mungu subhanahu wa ta'ala alituambia wa aqimus sala, simamisheni swala, wa atu zaka, na mtoe zaka. Hapa mpendwa wa Muislamu, ningependa tuzungumzie masala ya kutoa zaka. Umeona watu wengi Waislamu wanateseka, hawana chakula, hawana maji, hawana dawa. Tungeomba watu wasaidiane, hasa wakati huu wa COVID-19, hasa wakati huu wa lockdown katika hizi kaunti 5 za Nairobi, Machakos, Kajiado, Nakuru na Kiambu. Waislamu wa kaunti kama hizi kuna mambo ambayo kwamba yanawakumba, na si Waislamu peke yake, hata wasiokuwa Waislamu. Kwa hivyo tunaomba wale ambao kwamba Mungu amewajalia kipato kidogo, tafadhali tusaidie wale ambao kwamba hawana kipato. Na Allah akakwambia baada ya kutoa zaka, warka'u ma'ar raki'in, na uhakikishe una rukuu pamoja na wenye kurukuu, maana uwe ni katika kuwa wenye kunyenyekea mbele ya Allah subhanahu wa ta'ala. Wapendwa wa Waislamu, mambo ya swala si mchezo. Allah amesisitiza akatwambia hafidhu ala salawat, zihifadhini hizi nyakati za swala, wassalati alwusta, na swala ya katikati, yani swala ya alasiri kama tulivyosema, waqumu lillahi qanitin, na msimame mbele ya Allah subhanahu wa ta'ala ikiwa nyinyi ni wenye kunyenyekea kwa namna kubwa zaidi. Wapendwa wa Uislamu, Mwenyezi Mungu subhanahu wa ta'ala kukuonyesha umuhimu wa swala hasa ndani ya mtukufu wa Ramadhan, anakwambia kad aflaha almu'minun, hakika wamefaulu, wamenali saada, wamepata succession wale ambao kwamba alladhina hum fi salatihim khashi'un, wale ambao kwamba katika swala zao wanakuwa ni unyenyekevu. Kwa hivyo tutakuomba wewe Muislamu, unaposimama kuswali kuwa mnyenyekevu mbele ya Allah. Unakuta kuna Muislamu ama binadamu anapokutana na rais wa nchi ama waziri anamuinamia kwa heshima kubwa sana, lakini anapokuwa ndani ya swala anakuwa ni mtu wa mchezo. Ndio unaona watu wa siku hizi, mtu akiingia kotini kwa sababu anajua atapigwa fine, anazima simu mapema sana, kabla wengine wanasema mpaka akiwa nyumbani